Member. The topic for my today's discussion is use of ICT in teaching criminal law. ICT means information and communication technology. How can we use it in teaching, especially in teaching criminal law? You can find my phone number, and some of my lectures are uploaded on the YouTube. Those interested can also visit that. Now, what are the key drivers for today? This history of law teaching and technology. What is the meaning of criminal law? What constitutes teaching? What are the components of teaching? When we say ICT, what is the meaning of that? What are some of the experiments that I have made in ILI and experiences, good and bad? Case analysis and way ahead. Now, computers and law, they may be new to us, but first significant article can be found in 1953. Scientific Aids to Legal Research, Chicago Kent Law Review. Then 1969, Computers and the Law, an introductory handbook was published way back in 1969. 1970, another work came in the American Bar Association journal, Computers and Legal Research. Around 50 years back, more than 50 years back, things have started. That way we are not as advanced as the West was, and the reasons are very natural. But now, once we have started doing our teaching, our research through ICT, especially post-COVID or during COVID, I think in only sky is the limit for Indian intellectuals and legal researchers. In India, first important work was published in the Journal of Indian Law Institute, Delhi. It was in 1975. 1989, another work came in the form of proceedings, how the computers and law can be used. So that shows that we also started thinking about computers and law. But as we are a conservative society, love status quo, don't want to change easily, so it is not easy for us to shift from the traditional mode to modern mode. Though we started doing it fast, but one of the positive consequences of COVID was that we were indeed pushed to this modern technology, willingly or unwillingly. And probably one of the silver lining of the deadly COVID was that the Indian intelligentsia, the students, the faculty members, the researchers, the administrators, non-teaching staff, all are now aware of how the technology and the education are lifelong partners. When we say ICT, a lot of meaning. Way back in 50s or 60s, probably projector was one such means. We also used in the initial days. Projectors were used in conferences and seminars, and but not generally in the classes. Then computer network, computer data database, electronic informations, e-data, e-document, e-form, e-record, intermediary, internet, web address, domain name, email, pen drive, CD, scanner, and mobile phone, memory chips, smart boards, electronic pen, digital library, social media, Google Meet, Microsoft Team, and so on. Some are individual in nature, like cell phones. Some are having group facility like digital library. So when we say ICT, these are some of the meanings of ICT. As the topic is teaching criminal law and use of ICT, let us understand the meaning of criminal law, which I think most of the learned participants know very well. It will just refresh the memory. To begin with, crime is something which is punishable under law, punishable by a criminal court. So that makes the difference between crime and civil wrong, or maybe administrative wrongs. Now the criminal law can be substantive, can be procedural. Substantive criminal law is maybe Indian Penal Code, which is turning into Bharatiya Nyaya Sanhita 2023. Procedural criminal law, which talks about procedure to give remedy, like CRPC 1973, which is turning into Bharatiya Nagrik Suraksha Sanhita 2023. Then another form of criminal law is hybrid. Hybrid in the sense that the same law contains both substantive and procedural. So take example of Prevention of Corruption Act. It contains what are the offences, it contains what are courts, what are the procedures, which agency will start investigation. It talks about public prosecutor, it talks about bail. Take example of PMLA, it talks about bail, NDPS, UAPA, they talked about bail also. So it is hybrid in nature. Criminal laws, maybe some of them can be hybrid in nature because they are blend of substantive and procedural. So when we talk about using ICT, we should be aware that we can deal with hybrid criminal law also. Then some of the criminal laws are only empowering in nature. They do not indeed provide for any punishment. Sometimes they do not provide for some procedure. So take example of Armed Forces Special Power Act, only 7 provisions, no punishment at all. Nothing like bail provision, nothing like investigation provision. They are only empowering laws. So that way criminal law can be of many other classification. Now, when we go to teach criminal law, we have various components. One of the component is we go and teach, which is the principal component. Then there are other components like mentoring our students, guiding our students, assignments, other things. Then the examination is another component. when we prepare question papers for them, when we take class test for them. So can there be an online test also? Can there be an open book type test? Means where the students are permitted to use online resources that I am doing in ILI. But then when we say teaching criminal law, we do not only teach provisions. We do not only teach precedents. And therefore a criminal law teacher must be aware of the rule of P6. A good criminal law teaching consists of these P6 that I am going to elaborate. I have already elaborated in various other lectures, especially in cases of research methodology, but that is equally significant here also. P6. So P1 means principles of criminal law. Principles of criminal law not written. We go to the class and we convey the students certain principles like presumption of innocence, that an accused is presumed to be innocent unless proven guilty beyond all reasonable doubts. This is not written anywhere, neither in IPC, nor in CRPC, nor in evidence. This is inferred. For a new student, it is sometimes difficult to let them know where is it written. Because a student thinks that law means something which is written, passed by legislature, passed by parliament. But then principles are there, which indeed in the hierarchy is first. There are other principles also. Doctrine of mens rea is another principle, is again not written anywhere in the statute book in India. Though some of these principles of criminal law are mentioned in one of the chapter of International Criminal Court, Rome Statute of International Criminal Court 2002. But the principles are not written in Indian law, subject to 1-2 exceptions, like maybe JJ Act contains some of these principles. Earlier it was little difficult to trace these principles because they are not written anywhere. We go through books and we find some principles, some textbooks, and we let the students know, okay, these are the principles. We indeed start with these principles. But with the ICT, with the internet, we are able to trace the real origin of these principles. So while in books, we are only aware of what are the rules derived from DPP versus Wilmington case, that you know what happened in that case, DPP versus Wilmington. In that case, there was some hot talk between husband and wife. The relationships were not very good, but they were not very bad also. Then one day, the husband took his gun, targeted her wife, and told that I will kill you. And then he triggered, and ultimately the wife died. The accused was surprised. He said that I am surprised because I never wanted to kill my wife. It was just an accident. I always thought that the gun does not contain the bullet. I was only trying to scare my wife. I only wanted my wife to come and stay with me peacefully. I was only trying to create some fear in her, and I never wanted to kill her. So the prosecution said, we are not required to establish anything because the accused has himself accepted that the gun was his. The bullet used in the gun, he triggered the bullet. Wife was killed by that bullet, and therefore I need not to prove anything. It is the accused who had to prove he is innocent. But the court, House of Law, decided that no, even if he has accepted everything, once he said that he never wanted to kill, then the element of mens rea has to be established by the prosecution beyond reasonable doubt. This was the principle that came through Wilmington versus DPP. So, principle of mens rea, burden of proof beyond reasonable doubt. This burden is a burden of prosecution. These were some of the principles that were established in the case of Wilmington versus DPP. We all know these principles. These principles are available in the books. I remember my days of when I was a student. I wanted to read this case, full case. Of course, the books, the journals were available in the library. But then one has to go to see the library books and journals. You may not find journal because somebody has replaced it, somebody has misplaced it, or the journal is maybe sometime it is issued to a faculty member. Now the things have changed. In order to study, in order to read this Wilmington versus DPP, probably we will not go to see a journal. Why? We will go to Google. We will place the name of the case, Wilmington versus DPP, and then a number of results will come, and some of these results will give this case in so detail, and ultimately with some effort we are able to find the original case. So one of the biggest advantage of this ICT internet is that the original source, the law teacher or the student or the researcher need not to move here and there, need not to wait for the original source. Original source is available, easily available, on a click. Let me share another example. Those days I was teaching in Gorakhpur University, and a judgment on student union election came in, and the authorities in Gorakhpur University requested me that how to find this judgment. I'm talking about 2001 or 2, something like this, or maybe 2004-5, something like this. So everybody told that we have to wait for AIR, All India Reporter, which comes maybe after 15 days, 1 month. Or the other possibility is that we have to ring someone in Delhi. I ringed him, and then he sent the judgment through post. It took around 3, 4, 5 days. What is the situation now? Do we need to wait for the judgment and AIR, SCC? No. A judgment comes from the Supreme Court. Within 2 hours, 3 hours, it is uploaded. Take example of Arvind Kejriwal judgment which was delivered yesterday. That Arvind Kejriwal, the Chief Minister of Delhi, will get interim bail. A matter of Criminal Procedure Code, Criminal Law, PMLA, Prevention of Corruption Act. The Supreme Court has decided that yes, up to 2nd of June he will get interim bail. Now, many of us were very curious what is the content of the judgment. And within 2 hours the judgment was available. And the best part is that you need not to search for the judgment. Judgment will automatically come in a WhatsApp group which is made by, which consists of some legal scholars. So these are the biggest advantages of ICT, that unlike previous students, previous teachers, previous research scholars, the access to legal material has become very easy. So first rule is principle, criminal law principles. So we need to go into the sources of principles, sources of these principles. We can go, a law teacher can go and study those principles. Second is provisions. The provisions like 302, 299, 300 of IPC or CRPC provision. So the provisions. Now, so far as provisions are concerned, again, one can find a law easily. Need not to flip through the books. Of course, books are no replacement. Books cannot be replaced. Bare acts cannot be replaced. But for a criminal law teacher, that we do in the class, and I think many of you may be doing, at least I am doing in my class, that I start teaching something. For example, suppose I am teaching Unlawful Activities Prevention Act, 66F of Information Technology Act, which talks about cyber terrorism. And then I want to see what is the definition of cyber terrorism, or sorry, what is the definition of terrorism under UAPA. So in the class itself, one can easily go, search for the law, place it on his projector, and any student can find it easily. So this has become, the technology has came like a boon, and the information has become easier for us to find. So provisions can be easily accessed. We need not to wait for and flip through the books or ask someone to go to library, bring this book, I want to see this provision. Take another example. Voyeurism is punishable under Indian Penal Code. Stalking is punishable under Indian Penal Code. 354 A, B, C, D were incorporated through Criminal Law Amendment Act 2012. So when I was teaching this, someone recalled that, sir, is there anything under Information Technology Act that talks about privacy, private privacy, or privacy at a private place of a woman, and then it is provided under the Information Technology Act. Now because of this technology, so we should be very ready with that. If we have laptop in our class, and mobile phone is certainly there, we can easily find which section talks about privacy of women, and we can make a comparison between these two provisions. So for a criminal law teacher, when we talk about provisions, these provisions can be easily accessible at the click, and with the students we can discuss easily. Of course, the teacher has to be more alert because the student will ask many questions. But a good teacher should always be ready and encourage the students to come with a bare provision or keep their bare provision open. In my class, I have always suggested the students to come with their computers, with their laptop, or at least their cell phone open. I understand that in ILI there are number of students, there are only 40 or 30, unlike in many colleges where number of students are 100, or in 3-year course there are many students, in total 200, 300 students. In one class there are 70, 80 students. It will create some problem sometime. But then with some discipline, use of technology in the class will always be useful, will always be more purposeful, will always keep the student ready. Third rule is policy. So first is principle, second is provision, third is policy. Whether criminal law talks about some policy? Answer is yes. The zero tolerance policy for terrorism, we often have heard. Nip in the bud policy. So the policy that is, so these are the policies which sometime we use, especially in the postgraduate classes, but we may refer it to undergraduate classes in 1, 2, 3 lines, not more. But for the law teachers, it is essential to understand the difference between policy and principle in one line. That principle is generally universal or permanent in nature, but policy keeps on changing. If the government changes, the policy changes. Take example, that the current government, central government, wants to keep sedition law, but the opposition wants to remove sedition law. So if the government changes, then sedition law will be removed, the policy changes. If the government continues, the same government continues, the sedition law will continue. This indicates that the policy keeps on changing with the government. But the principle of innocence, presumption of innocence will remain like that even if any government comes. Then the fourth is precedent. So principles, provisions, policy, and the precedents. No criminal law can be complete without precedent. And therefore we often take note of precedents. So a new judgment has come on a particular issue, which has developed the rule of bail. Again, I will go back to the example of Arvind Kejriwal case. Now in the class, you can easily refer this judgment, all because of ICT. So judgment was delivered yesterday, and you can read and you can come in the class and then convey what are the grounds the Supreme Court has given. In the postgraduate classes, what I do in my classes in ILI, that if the orders are small, for example, this Arvind Kejriwal order or similar such order if they are small, maybe 7-8 page, I request the students to read the orders immediately and give them around maybe half an hour. PG classes are for 2 hours, so we can do this for half an hour. And after half an hour, they will discuss with them, 2-3 students will discuss with them what is the ratio decidendi of the case, what are the obiters of the case, what are the precedents used, what are the laws, provisions used, what are the principles that was used. So P1 is a principle, whether the judgment uses this principle or not. P2 is provision, what are the provisions that are used. P3 is policy, which policy the Supreme Court is trying to propound, trying to follow. P4 is the precedent, what are the precedents that court have used. Of course, for the undergraduate classes, there are limitations. In a 50 minutes class, the teachers cannot do, but in a class of postgraduate, we can certainly do it, and we should do it. 2-3 pages, 4 pages orders, sometimes 5-6 pages order. Can we ask the student to download and start reading, and maybe after half an hour we start discussing. Why is it significant? It is significant in the light of the fact that sometimes we give the students to study something and they are not prepared. So this happens in many places. So in my classes, if I tell them that you please read these things, sometimes there are genuine reasons. Though no sir, we were not able to study because we had an examination, we had some assignment we are completing. So I tell them, okay, you just download it, just 7-8 page. You give 5 minutes to every page, to 6 pages, 30 minutes, and after 30 minutes we'll discuss. This is how the criminal law teaching, especially in postgraduate classes, it is possible. Sometime in undergraduate classes also it is possible, but not regarding judgment, but some new provisions, a small provision that can be presented before the students, some new provision, and the students can be asked to convey their points. For example, take example of new sedition law. It is incorporated under section 150 of Bharatiya Nyaya Sanhita. So if I am teaching mens rea and actus reus in the criminal law class, I will just post the law on the projector, on the smart board, and ask the student, try to trace the mens rea element and actus reus element, and let the student discuss for maybe 5-10 minutes, and then ask, what do you feel? Let them write. So this is how some of the provisions, small provisions, can be used to develop a new type of understanding of laws, and will make the class more and more engaging. After P4, P5. P5 is professional opinion. Professional opinion is not law, but they help in making law. So what is the opinion of the Law Commission of India? Is a professional opinion. Law Commission of India has given its report, 279th report on sedition. I understand that these reports cannot be used very much in the undergraduate classes, but of course in the postgraduate classes it can be used. And for his own understanding, her own understanding, the teachers can use it and should use it. 279th report of the Law Commission. They are professional opinion. So what is the opinion of Professor Nigam, who wrote a very good book on criminal law, or maybe Smith and Hogan? Or what is the opinion of Hart? What Bentham talks about criminal law? They form professional opinion. And then P6 is practices of criminal law. A criminal law teacher, like any other teacher, must be aware of the practices. So we are aware that section 154 of CRPC talks about FIR, that in cognizable offence cases FIR shall be registered. This is the provision. The precedent of Lalita Kumari in 2015 Constitution Bench says that it is mandatory to register in case of cognizable offences, and preliminary inquiry can be taken only in exceptional 4 or 5 cases. But what is the practice? Practice is that it is very, very difficult to register FIR. Every day thousands and thousands or lakhs of FIRs are not being registered. This practice we are aware of. So these P6, a criminal law teacher should be very much aware of. For our convenience, we should just recall it again. P1 is principle of criminal law, P2 is provision, P3 is policy, P4 is precedent, P5 is professional opinion, and P6 is practices. So when we are teaching these practices that to our students, that see students, it is very difficult to register an FIR. Now the new Bharatiya Nagrik Suraksha Sanhita has come up with EFIR. The EFIR is in use in various states, but now CRPC, new CRPC or new Bharatiya Nagrik Suraksha Sanhita gives it a statutory recognition. So these are the things a criminal teacher should be aware of and convey the students. This is how the technology is being used. Now, in the classes, or in the seminar and conferences, the classical way of using ICT is the projector. I do not remember any of my class in Banaras Hindu University. I was taught way back in 1994 to 2000, or a single class was with the help of projector. But now we find even the small colleges, what to talk about universities, small colleges in Ghaziabad, they use the latest mode, that is smart classes. Smart classes are used in class 1, 2, 3, 4, 5 and also in colleges and universities. But there is always a debate. Should the criminal law teacher or any teacher use PPT in his class? There are always pros and cons for both. Those who do not use it, to oppose it, they always say that it creates distraction among students. They also cite some reports that class teaching is less effective when you use ICT in the classes. But then there are advantages also. These reports of distraction or reports of effectiveness are not scientific reports, but of course they are based on some studies. But I find that use of PPT in the classes are very useful. Number one, it is organized. It makes me organized. So once we are prepared that I will present a PPT, So I will be more organized. And after one slide, second slide, and third slide, and fourth slide will come, the slides will be connected. So even if there is some disturbance in the class, any student asks any question, he may ask. No problem, because the slides are ready. And my flow of class will not be disturbed. Second advantage to a teacher is that a teacher has to be more alert when it is a PPT class. Because the words and the sentences and the laws and the precedents and the principles will be displayed and the students will ask questions. So it is good for any good teacher. Journey from good teacher to great teacher begins from making yourself more and more alert and ready for the class. It is good that you are more alert. I have seen sometimes some of my friends say PPT में मत present करिए क्योंकि बहुत question होता है. I always think it is good. It will make me alert. If I do not know, I will just take excuse, and then next day I will prepare. Third advantage is that in a class is a group of diverse students. Students come from convent background. Students come from non-convent background. Students come from metro cities. Students come from rural background. Many of them are not good in English. If they are aware of the words, they are not aware of the spelling. So if some of these spellings are written, then the chances of mistakes will be reduced. I understand everything cannot be written, but take example of that in the class, LLB class, you go and convey the students that one of the doctrine of criminal law is actus non facet reum nisi mensi tria, and you do not write on board. I think 70% of the students will not write correctly this doctrine because it is maximus in Latin. So it should be written, and therefore any good teacher, he will write that maxim on the board. So in the PPT, if it is written, the students can write well. Sentences, maxims. So it is good for the students. Then third is, you can go back to the slides. So if I want to discuss something on P6, I can go back to the slide like this. Or I want to discuss what are the pointers for today. I can go and see this slide. That okay, I am discussing this ICT and teaching I have dealt with, and criminal law and experiments I am trying to share. So going back is always possible. And another advantage is you can share your PPT. Like after every class, I am requested that please share the PPT. PPT goes with the participant. It remains with them. Sometime I find a PPT which was shared to me 10 years ago. When I use this, sometime I search for something and I find, oh my God, sometime 2015, a PPT was shared with me. I'm looking for that, and that PPT is found. I'm very happy. I do remember those teachers. You create a permanent impression in the mind, heart, and soul of the student or the researcher. So this, I think, therefore, I always suggest that teachers should be very well prepared in the class, but at the same time, he should go with the PPT. But let me tell you, when we make PPT, we make certain mistakes. Especially the PhD scholars, Sometimes those who present, they make various mistakes, and one of the mistake is that they place everything on PPT, all sentences. So let me show you a slide, which is of course useful. See this slide. This is not the way to present the PPT. Please don't go in the content. If the time will permit, I will discuss with you the content. But what the teachers do, what the presenters do many times, is that they fill the whole slide. Indeed, there should not be more than 15 words in the whole slide, or maximum 20 words. So the slide should not contain more than 20 words. 7 words horizontal, 7 means rows vertical. This should be one of the rule that we should follow in our classes, and then the students will learn from us. So many students, they present their assignment and sometimes dissertation, and when go to PhD, I am surprised to see at the level of PhD also they commit these mistakes. Let us not do this. Unless it is very much essential. For example, you want to quote the law. For example, you want to quote the judgment, is part of judgment. Now, technology, use of technology in law teaching, I have discussed with you the classical way, that is use of projector. How we are using, or I am using, the social media for the purpose of classes with the students. Can the social media be used, and we are positively using it? Now, almost in every college or university, there are official groups of WhatsApp to convey the students various notices. But can a teacher use social media for the purpose of regular teaching? And let me give you my example. I teach in ILI Judicial Process and National Security, 2 papers. They are special papers. Judicial process means decision making process, what goes inside the mind of the judge, and what are ratio, decision die, appointment of judges, delay, so many things. National Security Laws is special paper, so UAPA, terrorism, sedition, armed forces special power, these things we study as a special paper. What I have done, that I have made an unofficial group of the students of judicial process and national security. I have requested the student that these are the link, and those who want to be a part of it, they want. I don't push any student, don't compel any student to be a part of that group. It is always okay for the student to be a part of that group, or to be not to be a part of that group. So this group is only a type of helping group after the class. What are the advantages? Advantages are that you are regular in touch with the student, 24 hours, which I think many teachers do not like. But I personally have felt that it has never been disadvantageous to me. Indeed, it had been advantageous to me many times. 24 hours I am in touch of the group. I have conveyed the student that you place relevant material, and so a judgment was uploaded in the evening, and some student has uploaded the judgment on my group, and I am reading the judgment. Some development took place in USA. Some student came to know that okay, that judgment is useful, that development, for example, appointment process in USA. For example, some judgment was delivered in USA. So a student has posted that news in the WhatsApp group. See, the advantage, dear friends, are that you need not to look for the material to update yourself. The students are giving you material to update yourself. 24 hours. Of course, if you are busy, you may not read, that is a different matter. I understand that after the class hours, it is very hectic, it is very busy, we have our business at home, our own family, our own commitment, that is understandable. But it is always in your control. You may not see that, you may not read that, but at least the material is accessible. So when I am in metro train, I am on maybe on a cab or maybe an auto, I try to see that during those times. So one of the experiment that I have made, and it's a very successful experiment, is that unofficial group of the students where we share the information, and if a judgment comes and I read, I give my opinion, and my students either give their thumb impression or sometime they convey their maybe doubts also immediately. So it has enlightening experience for me, and therefore I request you to try for this experiment, and I'm sure some of you may be trying for that. Now, in the evening, when you are preparing for the next class, you find a very good material you want to share. Of course, you can share online through mail, but you can share on WhatsApp also. So study material can be shared, especially in the postgraduate classes and PhD classes, and sometime maybe undergraduate classes also, because some of the undergraduate students are very good. So you can immediately post that material and convey the students that please read this material and tomorrow I am going to discuss with you. So 24-hour study material, more opportunity for interaction. Sometimes thoughts come later on. In the class you have discussed something, the student also discussed something, but later on the thought came in. The student may post it. Sir or madam, what to do in these cases? How to take this type of laws? How to interpret it? Then there are options for polls in WhatsApp group if some of you have gone through. And what I have done is, not always, sometimes I place some questions on polls. They are multiple choice question. Not always, maybe twice in a month, not many times. So MCQ type question, if you have used a WhatsApp group, you many of you would know that poll you can do, and that is MCQ type questions can be asked. Indeed, I have requested the student to place those type of MCQ in the group if they come to know about something, and sometimes I think that there are diverse opinion and good debate. Then I told you new cases, new law that can always come in, or you can convey that, okay, I want this law, please post it on WhatsApp. So I can anytime. So now you are a type of 24-hour a law teacher, a law researcher. But I understand that with home commitment that are household commitment, especially for lady teachers, I'm not telling to compromise that. But these are the ways that one can take care of this use of ICT in modern way. Then what is the limitation of these type of thing? That in group sometimes happens that no participation, even in the group. So for 3, 4, 5 days, no student will participate. And I have to ask, why are you not participating? Why no opinion? What happened? So don't think they will start immediately participating. then it can be a continuous disturbance, especially in if there are LLB classes. There are various types of students. Someone will post something which is very sensitive news, religiously caste sensitive news. So these are the limitations that we should be always be very careful. Indeed, it's a type of training also, but that does not mean if these type of materials are posted does not mean we should not use it. Indeed, these are the types of training for these students, preparing for future, not to post these type of materials. Convey them, this is completely illegal. You cannot post defamatory material. Of course, criticism is welcome. Then irrelevant posts will always come. Good morning, good evening, and RIP, RIP, and then गुलाब का फूल, भगवान की फोटो वगैरह वगैरह. So we have to check these tendencies. Another problem is that in unofficial group, the number of the student is available. So therefore I always suggest that don't push the student to become a part of that group, because there may be students who do not want their number to be shared. So these are some of the limitations when you use this thing. Fortunately, in LLM classes, in ILI, these problems are not there. There are no continuous disturbance. The students are very mature. They are very good students. So I don't face it, but no participation is one thing that I face. But I understand that it is not easy to enforce in other colleges, but you can think of based on the situation. The second thing that the ICT can be used in modern way is that after the class, what I am doing is I have requested the student to place a summary within 1 day, within 2 days. Summary of my class, and that is possible always in PG classes. If you are teaching in PG classes, that is easily possible. In undergraduate classes, it is little difficult but not impossible. So after the class, the students are required to present a summary next day or day after tomorrow. Summary of what they have read in the class, what they have studied in the class. It will make the student more attentive. What I have done is that I have told that you can make group of 2-3 students and you have to give a detailed summary. The detailed summary does not mean just in one page. So if I said that in Maneka Gandhi this happened, that the Supreme Court decided that law has to be just, reasonable and fair. So I have asked the student that don't just write Maneka Gandhi, do write the citation. Now go and search for the citation and give the summary online, not offline. Send me the summary online. For this purpose, every class I have made a special maybe mail ID. So I teach judicial process gmail.com is one ID. National Security, another mail ID. Students will send their summary in that. So your own Gmail will not be disturbed. So they will be more attentive. Of course, the chances of copying will always be there. But just because there are chances of copying does not mean we should not try to have an out-of-box thinking. That also conveys what you have delivered, what you have conveyed, to what extent it has reached to the student. Because it's our duty. Our duty is not only to deliver in the class, our duty is also to know whether the student is able to understand or not. Not 100%, at least 70 to 80%. You will be able to know that, okay, out of maybe 60 students, these are the 10 students or 12 students, they have not understood what I wanted to say. They are either not attentive or maybe they need more attention. They are good in language or they are not good in language. So that way the institution can understand how to groom these students especially. So their language has to be improved. So there can be a language class if you improve the quality. So if these things are being done, you can always incorporate in your CV that you have done some innovation in the CV, and in the API format also some innovation is always a part of that. You can always find point for these type of innovation. The institute can also encourage, because those institutes which are going for NAC, they are also looking for innovation, marks for innovation. These can be innovation. Yes, our teachers on a regular basis ask the student to send their summary and they convey their points. It is a type of feedback on your class. So those who deal with NAC or NIRF ranking, they understand that feedback has become a special measure. So use ICT to get the feedback of your class and improve yourself. Oh my God, this point I have conveyed in one line and no student has mentioned, and I have often found it that a very important thing I have discussed, and I found none of the class has discussed it in their summary. So next day I come and discuss it in detail, and then some of the students say, "Sir, कल तो समझ में नहीं आया था, आज समझ में आ गया sir." The student do not complain you last time. When you ask if you want to raise any question, they will not. But then when you ask them to write summary, then you will be aware that these are the gray areas where I should improve. Then I told you, especially in PG classes, don't tell the student to copy what you said. They should be critical. So strength and weaknesses also. So take example of capital punishment cases. You are teaching capital punishment and you have done your class, and after the class you said that you send me a summary, but it should be a critical summary. What is the meaning of critical summary? Critical summary means, should capital punishment be retained or should it be removed from Indian system? And let them write their opinion. Maybe in LLB classes it can be 2, 3, 4 lines. In PG classes it can be 2, 3 pages. Then ask the student to study something on that. And the PG class it is always possible. In undergraduate classes also it is possible, especially when you are taking classes on Friday and Saturday, Sunday is holiday. Especially when there is vacation coming. So you can say that after vacation I will see whether you have sent the summary or not. And in the summary whether you have discussed whether the capital punishment should be retained or capital punishment should be removed. So have you read some material? So some of them will go to Law Commission report. You will be happy to see I have not mentioned the Law Commission report, but the student has mentioned Law Commission report. That is your success. Such success story can be used maybe in the CV, maybe in the NAC, maybe in the NIRF ranking also. Then new information. Whenever I ask the student to send me summary, not all, but some students have come with a new information. A information which I was never aware of. Okay, this type of law is also there, I did not know. Let me give you a small example. I was teaching human right or law of women, law regarding women in one semester, and I was discussing sexual harassment cases. So when I asked that you please write a summary, send me a summary, One of the students has sent me, and you see, the Sexual Harassment Act of 2013 is not a criminal legislation. It is for the purpose of administrative. It is for administrative procedure. It is not a criminal law. And I told them it is not a criminal law. Then one of the students has written that in Tamil Nadu there is an enactment on sexual harassment which is also a criminal law. This was a new information for me. ये कहते हैं ना बैठे बैठे आपको नई चीज मिल गई. So see the advantage of this for a law teacher, for a criminal law teacher or any teacher. Then it a type of revision for student also for teachers. And the best thing is that for the purpose of the examination the students are ready. Students initially take it with a pinch of salt or do not like it very much, but when it comes to the examination the students always say, sir आपने जो summary दी थी ना बनवाई थी हमसे बहुत अच्छा रहा सर, क्योंकि now during time of examination I am not looking here and there and the exam and the reading material is ready, sir. It is also a type of pre-research writing. You are conveying the students how to do research work, preparing good students for LLM and PhD. Now you will ask that suppose the student do not write summary, what do you do? What I do is I have made the attendance subject to the summary. Not in all cases. I'm not adamant on that. I tell that okay, if you are not able to submit the summary today, please submit today. Your attendance is suspended. Sometimes the students say that I am in the class, my attendance should be there. These problems will come. You should not be very strict, you should be liberal, but at least give them a message that some summary would be required. Maybe in postgraduate classes, at least 2 summaries. Means if you have taken 4 classes, 5 classes, at least 2 summaries. In the undergraduate classes, at least 1 summary in a week to begin with. Now the problem is that in undergraduate classes, the limitation is how do you examine? It has come to your mail ID. A student may send it to WhatsApp group also. How to examine all? It is not possible to examine 60 summaries. I am aware that teachers have the great workload. So some of them you can examine and find how to improve. If it is postgraduate, then it can be done because number of classes are less and the number of students are also less. And if you are a senior teacher, you can request your PhD scholar also to help you. So these are some of the new things that can be done. Now I know that I have around 10 minutes more, so I will go to use that how this video link can be used sometime. So I was teaching SC/ST Act in one class and I thought that okay, I told the student that see what is happening, that even after 50, 58 years, 75 years, even that scheduled caste, scheduled tribe student is, or scheduled caste, scheduled tribe persons, in some cases, not in all cases, in some cases are not being treated well. Even we have a constitution, Article 17 is there, and then the examples are that court convicts 9 for preventing Dalit groom from riding horse on wedding day. So these news item can be presented before the student. Still it is happening, but at the same time the good thing is that the court has convicted. Now you have presented both the views. You have presented the problem and you have presented the remedy also. That of course these type of bad practices are going on, but now the courts and the police is alert and people are convicted. Sometimes we may also show some of the videos because of this internet link, and I will try to play one of the video.
हमारा पूरा पुलिस प्रशासन आपके साथ है, ठीक है। आपको जैसी राश निकालनी होगा जैसी निकालने के लिए हम तैयार हैं। दूल्हा जैसा बोलेगा, जहाँ से बोलेगा, जिस रास्ते से बोलेगा, जिस तरीके से बोलेगा, उसको स्वतंत्रता है, वो जहाँ से चाहे वहाँ से अपनी लाश निकलवा सकता है।
आईपीसी और अन्य सेक्शंस में एफआईआर की गई है और गांव में अभी शांति हमारा गार्ड लगा हुआ है और जल्द से जल्द इसमें जो आरोपी हैं इनकी गिरफ्तारी की जाएगी।
So it is only with the use of technology that you can immediately use a small YouTube link to convey the students that see these type of ill practices which are removed, which are abolished in 1950 by the Bharat Ratna Ambedkar ji and their team and the constitutional experts, architects of the constitution. We made laws in 1955, we made another law in 1989, but still these things are going on. But the good side is that the police is taking action. Police is ensuring that yes, he has a right to enjoy his marriage the way he wants, and the police will do. So these technologies can be used in the classes in a limited purposes. Now finding material online has become very easy. I have told you, you can find bills, you can find acts. In India Code website is there where one can find all the laws. Bills can be found in Rajya Sabha and Lok Sabha websites. In ILI and like in many universities, many materials are online available which can be shared with the teachers, shared with the students. Now I will just discuss with you a small case. A news item came that High Court imposes rupees 15 lakh fine on Allahabad University teacher for false case again on sexual harassment. This was a news item of February 25, 2024. And so what a law teacher should do, criminal law teacher should do, that he should go and read this news item. This is one way. It is published in Economic Times. But a law teacher should go for the original case. If you want to make a very good case analysis, one should look for original case. Original case, preferably from SCC website, not from Indian Qanun, because Indian Qanun, sometimes there are some problem in Indian Qanun, though it is a good website. But SCC or maybe AIR, they are good website. So you should look for original cases. Though Times of India, Economic Times, they are very trustworthy website, but one should look for. When I looked for the original case, Indian Express also quoted like this 15 lakh fine on assistant professor for a frivolous case against colleague. The original case suggested, original case judgment, you see this part of the judgment. It says, this is a perfect case where exemplary cost should be imposed on the complainant. The loss of reputation, public image and financial loss caused to the applicant are much more. But as a token, a cost of rupees 5 lakh is imposed on the person who is guilty of using abuse of process. So I was just wondering, when it is written 5 lakh, how the news item has said it is 15 lakh. 5 lakh on number 2 means 5 imposed on this, and the loss of reputation caused to the applicant are this. This amount should be given to applicant forthwith. Means applicant means a person who is aggrieved in this case. So applicant shall be given 5 lakh rupees. What is the news item? See, news item says imposes 15 lakh fine on assistant professor, 15 lakh fine another teacher. So why this is so? Because there are 3 complaints and 3 different orders were passed, and for each order 5 lakh rupees worth given. So that is how, in order to make case analysis, one should see the original case, not from news item, not from some website. One should do. So with that, I think I should close it. If there are any questions are always welcome. I thank again the college, principal of the college, other persons, other learned faculty members who were in my touch. Thank you again. House is open for any type of question, comment. Thank you.
Thank you so much, sir, for your enlightening words, especially in relation to how to deal with criminal law. And this particular way of teaching, especially a criminal law, will definitely help us when it comes to a very good on teaching and understanding the criminal law, which is there in this behalf. On behalf of SPPU Pune, HRDC, MMTTC, I take this opportunity to thank you, sir, for his valuable time, especially in relation to a very good on FDP program, enlightening us as to the criminal law and use of ICT while dealing the subject called as criminal law. Sir, if I want to share my experience, I just want to tell you that when it comes to criminal law and use of ICT, it is little bit tricky to understand and grasp the same. So with your method, definitely we all will, it will be helpful for all of us, and we will try to implement the same when it comes to a very good on teaching of criminal law and having new approach when it comes to a criminal law teaching by you, sir. Thank you so much, sir, for your valuable time. And I thank our principal, Dr. Sunita Adhav ma'am, our chairman CDC, Advocate Ashok Palande sir, vice chairman of Deccan Education Society, for his instant support, as well as our chairman of Deccan Education Society, Shri Pramod Rawat sir, for his guidance and support for all our ventures. With this, I declare the session by Anurag Deep sir from ILI is over, and those who have their presentations, please do kindly wait. Thank you so much, sir, for your valuable time and guidance. Surely we will take this particular insight from you and make our lectures very structured when it comes to a very good on discussion of criminal law.
Thank you.
Thank you so
very
much, sir.
Thank you
Thank
very much.
sir.
I will just
Yes, sir.
I will just request the participant to visit the YouTube channel Anurag Deep ILI,
Yes, sir.
and they will find a lot of material on research methodology. A lot of material. Anurag Deep
Yes,
ILI.
sir.
Thank you. Thank you again.
Yes, sir. Thank you so much, sir. Thanks a lot.